And this is today's Mandingo, where the counsel for the appellant, Mr. Fussy, the claimant in this case. My learned friends opposite, Mr. Walaba and Mr. Kachale, are the counsel for the respondent, Sir Delirium Terminus. Would your lordship like a brief summary of the facts of the case?
Yes, please.
In this case, Mr. Fussy lent his brand new Ferrari testosterone worth £500,000 to his friend Stade in order to visit his aunt in the country. Losing his way, Stade decided to stop and ask directions. Seeing a drive leading off the highway, Stade drove the car and parked it and walked to the house door. They are arguing the defendant didn't take the necessary precautions for the claimant to avoid injury due to the potential harm posed by the activities undertaken on the land, but was quashed as the defendant proved that they did take necessary precautions. But in this case, as I said, Sir Delirium did not take necessary precautions.
I am Mr. Nemiji Gajale, Senior Counsel for the respondent, and I will be arguing on a small basis. Our arguments as the counsel to the respondent will mainly be on the grounds that, firstly, defending the common law and negligence principles under which our claimant may or may not apply, and secondly, showing that our client is not in fact liable under the Occupiers Liability Acts of 1957 and 1984.
And one of his arguing points is that negligence isn't entirely included in the Occupiers Liability Act of 1957, and he argues that it should take a more vital or more crucial role in deciding using the Occupier Liability Act.
But now, under the OLA Act of 1984, Sir Delirium Tremens does not owe a duty of care, as there is a three-part test of the duty owed to a trespasser, of which the three requirements must be met, or otherwise there will be no duty owed. May I say these three criteria?
You defined being reasonability as a man off the street. Don't you think Mr. Stade fits that description a lot more than the guy driving a tank on his property?
Where is there a law which requires you to state if you have a tank in your house or in a residential area, I believe? Let's say, for example, when you have a dog, you put out a warning that I have a dog at my place, so if you do decide to enter and it bites you, it's not my fault. So the tank, is there a law which requires you to state that I have a dangerous vehicle in my property, so if you step here, there's a possibility of you getting hurt? So that's my question.
The same goes for the common law argument, as if all the tests in common law are not met, the law does not allow the common law test to apply, as this would again bring in an element of injustice and unfairness. Thank you.
As I say, it is customary to clarify the actual discretion. Thanks very much. You're very pleasant to
Sogandie, osa ukayo.